Okay, guys, welcome back to another edition of Lawyered Up. This is kind of a fast one because we just had a Lawyered Up, but we had a great decision come down the pipe, and so we are going to be joined by Mary Kathryn Nagle. She is a Cherokee playwright and lawyer, and she is also representing the Muscogee Creek Nation and the Hickory Ground in the most recent appeal to the lower district court's dismissal of the case. If you guys don't know what I'm talking about, in the description of this video, there is a link to the prior live stream on Lawyered Up we did that has all the history of the case and the breakdown and all that stuff, and Mary Kathryn joined us for that too. There's also a link to the most recent decision by the 11th Circuit, so if you guys want to read what we're talking about, click on that and check it out. And I want to tell you guys too, since Mary is here, if you have any questions for her, please let us know, and we'll ask them. So with that being said, thank you so much, Ms. Nagle, for joining us today.
Thank you for having me, and our daughter, Mvskoke, who is joining me for this call.
She's giving her technical input there. So
it was at the courthouse in Atlanta.
Yeah.
So,
she was even in the press conference. You know, if you check out the live stream, we live streamed the press conference afterwards. So I guess the first thing I would say is could you break down what happened with this decision and where that puts us right now?
Yeah, so I think the important thing to know about this decision is it is a huge victory. The significance of the win could not be exaggerated. That said, the whole case isn't over. We still have a long road ahead of us, and it's kind of hard to understand that, but that's just unfortunately how litigation goes. Because in the district court, our case was entirely dismissed, and the court basically said, you can't bring these claims against any of these defendants, all three, which is the Poarch officials, the federal defendants, the different agencies and federal officials, and Auburn University. Winning in the 11th Circuit means we get to go back to the district court and litigate our claims. It's a huge victory because if we had lost, the case would have been completely over, and there would be no justice for Hickory Ground, and there would be nothing that could be done. So it's huge. I think if you look at the history of the case for the last 20 years, it's just been a series of losses, right? You know, Miko Thompson asks the Bureau of Indian Affairs to do something about the excavation of relatives at Hickory Ground. BIA ignores it. The nation files a lawsuit, asks the district court to stop the construction. The district court rules against the nation. You know, so you look at the history, and it's just been, even though I think the law is clearly on our side, the federal courts and federal agencies to this point in time have not upheld the law, and this time they did. And we have a long road ahead of us, but we do have a road ahead of us. And so Instead of being at the end of the road and it being a dead end and having no options for justice, we now have, we have the chance to go back to the district court and litigate our claims against these defendants. And so what it means from now on is that we're going to go back, we're going to amend our complaint, and we'll probably face more briefing from the defendants as they try to get rid of the lawsuit. So again, I just want everyone to know, I think we really should celebrate this win because I don't think anyone thought we would win, and certainly I don't think Poarch did. You know, I think they thought that they weren't too worried. I'll just say that. So I think everyone, and we're all very pleasantly surprised, isn't quite the right word, enthusiastically happy and surprised about the decision, because these are really tough cases to win, and it's just really an incredible victory.
Yeah, definitely. And also we should discuss what the court decided, because basically, and you correct me if I misstate here, but the court said that the dismissal was based on kind of a blanket sovereign immunity, and it wasn't based on individual claims. And that's what they've told when they remanded the decision, they told the district court that need to go back through on a claim by claim basis. Could you talk a little bit about that?
Yeah, so our complaint is fairly complex because we have so many different defendants. We have claims against federal agencies for their violations of federal law that really have nothing to do with Poarch. It's just about how the federal agencies violated federal law. We also have claims against Auburn for their violations of federal law. And then we have separate claims against the Poarch officials. And we had claims against Poarch Band as a tribe. Those were dismissed under sovereign immunity, and we did not appeal those. So Poarch as a tribe is gone from this lawsuit permanently. They're no longer a defendant. However, there is a doctrine called Ex parte Young, which allows plaintiffs like us or any other plaintiff to sue state or tribal officials for their ongoing violations of federal laws if the only relief you're requesting is injunctive, non-monetary relief. So basically, what we're suing for is the ongoing violations, the current violations of federal laws that the Poarch officials continue to engage in. And we're not asking the court to award us money, we're asking for prospective injunctive relief, which is something that the Supreme Court has upheld numerous times for hundreds of years. It's a very well-known doctrine. State and tribal officials get sued all the time in their official capacity under Ex parte Young. And so what the 11th Circuit did was when they looked at this, they said, okay, the district court said, oh, Poarch Band as a tribe has sovereign immunity, therefore all of the claims, the entire lawsuit has to be dismissed, and that's just wrong. And that's not how courts are supposed to do it. And of course I agree with that. Because you don't, for instance, the district court looked at some of our claims against the federal government and said, oh, well, that's going to violate Poarch's sovereign immunity. Well, it has nothing to do with Poarch. The federal agencies have a federal trust duty and responsibility to protect sacred sites, to protect Muscogee burials because of the federal agency's trust relationship with with Muscogee Creek Nation. It has nothing to do with Poarch, right? Mm-hmm. And so those claims should not have been dismissed because of Poarch's sovereign immunity. Now, whether the Poarch officials can continue to be sued is something the court will have to consider on a case-by-case basis. I do think the language the 11th Circuit offered in this decision is incredibly helpful to us in that analysis, and I think we have reason to be hopeful about our ability to still hold the Poarch officials accountable for their ongoing violations of federal laws based on what the 11th Circuit said in its decision.
Okay. One of the other things, we talked about Ex parte Young just now a little bit. One of the other things that was mentioned a lot in this decision was Coeur d'Alene. Could you kind of, if you can, fit that into a nutshell for the audience? What does that mean? What is that?
I know. It's sort of mind-numbing, all of the legal doctrines that get involved. Because at the end of the day, and it's hard because you've got 57 relatives at least who were illegally excavated, put into trash bags and plastic bins, and that's really what this case is about. However, as the attorneys, what we have to talk about are these archaic doctrines and whether these three factors apply here, or whether this doctrine is still good law, and blah blah blah. Right. And so the Coeur d'Alene case is one of those complicated doctrines. It's a case from the 1990s where, again, the Ex parte Young doctrine says, hey, if state or tribal officials are engaged in ongoing violations of federal law, you can sort of get rid of this sovereign immunity just for the sake of those claims to ensure that state and tribal officials are complying with federal law. Coeur d'Alene is an exception to the exception. So Ex parte Young is an exception to sovereign immunity. Coeur d'Alene is an exception to Ex parte Young. Now, we argued this in our briefs, and we did lose on this particular point. We said, hey, lower courts no longer apply Coeur d'Alene after a 2002 decision in the Supreme Court called Verizon, because lower courts have recognized that Verizon sort of abrogated or overruled Coeur d'Alene. We didn't win on that issue. The 11th Circuit was very clear. No, Coeur d'Alene still controls. But what the Supreme Court said in Coeur d'Alene is, okay, you can't bring Ex parte Young claims against state officials if really the heart of the issue has to do not with ongoing violations of federal laws, but with just who owns the land at issue. Whether
I see.
Which sovereign owns the land. And so our response to that was, well, hey, none of our claims have anything to do with ownership. Poarch will still own Hickory Ground. They'll just be required to comply with the federal laws and their promise to protect it, right?
Right.
And I think the 11th Circuit was pretty sympathetic to our argument. They didn't technically rule on it. They said, we have, this needs to go back to the district court, and the district court needs to consider this in the first instance. But when we get back to the district court, I think we're feeling hopeful about how that analysis will go, because We're not asking the court to award Muscogee Creek Nation ownership of Hickory Ground, even though Muscogee Creek Nation was the rightful owner of Hickory Ground for millennia, right? Long before Poarch even existed. That being said, none of our claims would take ownership away from Poarch. And in contrast to Coeur d'Alene, where there really weren't any allegations of ongoing violations of federal law by these state officials of Idaho in that case, it really was the plaintiff in that case really just wanted a declaration that the plaintiff owned the land at issue. We have numerous violations of federal law alleged in this lawsuit, and so it is very different than Coeur d'Alene, and that's something the circuit pointed out. And so I think we'll see. There's no guarantee of what'll happen in the district court, but it's decently favorable to us at this point based on how the 11th Circuit wrote its decision.
Gotcha. We've had a couple of questions pop up here. T.Y. Prohl asks, would it be a correct assessment to say this case is a litmus test whether Uncle Scam is serious about upholding the spirit, intent, and letter of the law of NAGPRA for Indian country?
I think that's absolutely right. And I think that, the United States, there's several federal agencies like, Department of Interior, Bureau of Indian Affairs, National Park Service that are defendants in this case. They've filed documents themselves in this case showing that they knew Poarch and Auburn were violating NAGPRA, and they didn't do anything about it when they should have, right? And I think that what's hard for Native people who believe in the rights that are enshrined in NAGPRA, which is, hey, Native burials are just as sacred as Christian burials, right? There's no reason why a Native cemetery or burial ground should be desecrated without consequence, whereas Arlington Cemetery is going to be protected as it should be, right? But there's, what NAGPRA says is no, Native burials get the same protections under the law, right? But we've seen that even though NAGPRA says that, it's not the same, right? There's this huge disparity in terms of the protections our relatives get and non-Native relatives get. And I think this case is really about whether or not the federal government can continue to just look the other way, which they do all too often when it comes to protecting Native burials. Look at the Standing Rock case, which is another case I worked on. You had the former TIPO for Standing Rock filing a brief in federal court on the Friday before Labor Day weekend in 2016 saying, mapping out where 27 burials were in the path of the proposed Dakota Access Pipeline. The very next day, Dakota Access went out there and used that mapping to actually dig up the burials and desecrate them so it would no longer be an issue in the, blocking the progress of the pipeline. I mean, sort of the same thing Poarch did here in building its casino, right? And what did the federal agencies do about that? Nothing. And, and that clearly was a violation of NAGPRA and other federal laws. And so, at some point, either Congress needs to get off its butt and amend NAGPRA to give more teeth to it so that there are more consequences when federal agencies do this. But I also think the law is clear on its face, what it says right now. And federal agencies, there needs to be political pressure and societal pressure from American culture at large to require these agencies to obey these laws, because all too often they do look the other way. Native burials get destroyed, and the laws that are on the books are not being upheld.
Yeah. We got another question here, and it is from T.Y. Prohl again. He asks, are there wider implications to the eventual outcome of this case in Indian country beyond just the Muscogee Creek Nation and the Poarch Band's conflict being resolved? And we kind of just spoke about the wider implications there with your mentioning of Standing Rock, so I think we kind of covered that. He also asked, is there any legislation that Congress would enact to address issues like this, and what would you suggest?
Well, I will say really quick, to answer that second question, yes, I did answer it, but there's another thing to think about, and that's that, this is an issue that affects any tribe that has a Trail of Tears. Because if you're, and that's a lot of tribes in Oklahoma, right? If you're a tribe that was forcibly removed from your homelands, you were separated from the burial grounds of your relatives. And federal law protects their burials, but if you're not literally there, and if another tribe can come along, let's say a more recently recognized tribe, or, sometimes our boundary lines overlap. I mean, Jonadev, my husband, and I are constantly debating where Cherokee Nation began and Creek Nation began in northern Georgia, right? So we sometimes have overlapping historical boundary lines, and this case also raises a question of can a tribe violate federal law with impunity and dig up the burials of another tribe just to build a casino? I don't think federal law lets anyone do that.
Yeah.
But that's kind of what Poarch is arguing here, and I think it's an important question for Indian country to answer, because as we gain more economic power as tribal nations, tribes are going to be seeking to do things economically, and we need to, as Indian country, be clear on what our collective understanding is, not just of federal law, but of the morals of it. Are we okay as Indian country letting removed tribes have their burials desecrated by later in time tribes that come along and just want to build a casino or other economic development? And so that's kind of a primary issue for us. And I apologize that.
Oh, you're fine. I did want to point out another aspect of this that we haven't talked about yet, because we were just discussing the dividing lines between where, like, for instance, Cherokee Nation stops and Creek Nation or tribe. And one of the concerns with this case is that the Poarch are going to take information that they find out about where other ceremonial grounds or the original ceremonial grounds are, and they're going to make claims on that to try to get that land, and then they're going to dig up those ceremonial grounds to put casinos there. Is that one of the concerns that
I think that's a huge concern, and they are currently pushing for legislation in Congress, specifically HR 6180, to basically give them the legal ability to get land into trust anywhere in Muscogee Creek Nation's historical treaty territory. And of course, the Creek Nation has taken a public stance against that legislation, asking our Oklahoma congressional delegation not to allow it to move forward. That's HR 6180. And I think it's concerning for any removed tribe that another tribe could come along and try to get your sacred sites into trust just to dig burials up and build more casinos. But I think Poarch does have its sights set on other sacred sites within the territorial, the Muscogee Creek Nation historical treaty territory. And so I think it's a huge issue and huge concern for Muscogee Creek Nation right now.
Yeah, and that's the issue with this case too, is if there's a bad decision that we get here, or a decision that allows the Poarch band to do what they're doing and there's no repercussions for them, there's going to be nothing to stop them from going ahead and finding these other sites of other ceremonial grounds or original towns, and then digging up the remains and artifacts, and then building their casinos there, and
exactly.
They've shown that they'll do it, there's no moral thing for them. They're like, it's cool.
That's exactly it. And so I think that it is hugely concerning, and I think that there are other. Well, think about it. I mean, there are other sacred sites that they have their sights on, and the nation has had to be very vigilant in protecting against that.
So, with this situation that we're in, because I know there was some discussion in the case about under NAGPRA, the Poarch band having to consult with the Muscogee Creek Nation, and that they didn't actually do that stuff. Or they sent a letter.
We're talking about burials. But this is a Halloween skeleton. It's sort of weird to grab the skeleton, but it's a Halloween decoration.
Is that going to play into this amended complaint at all? That they're on the NAGPRA violations? So
Poarch in 1999 signed an agreement with the National Park Service requiring Poarch to consult continuously, not just once or twice, but always, with Muscogee Creek Nation with regards to any action Poarch takes with Hickory Ground, because Muscogee Creek Nation has specific religious and cultural connections to Hickory Ground. Poarch hasn't done that, and that's one of the things we're seeking in this lawsuit, is to require those officials, the Poarch officials, to commence those consultations and engage in them as required by federal law. I think that they clearly don't want to, but hopefully that is something that will come of this litigation, is that will start to happen.
Okay. We've got an off-topic couple of questions here, and I'm going to try to squish them together and make one question out of them. But in your legal opinion, and I know this is, I don't think you're representing the tribe in any lawsuits there, but the Creek Nation does that have a sovereign claim to the Arkansas riverbed?
Oh, you know what? I'm definitely not the person to ask to answer that question, but my guess is that there could be some real good legal arguments about that. But I know that's.
Is there a lawsuit going on that you know of?
I don't know of, but I mean, I wouldn't necessarily be informed of that because the tribe has several lawsuits and has really good attorneys representing them, and I wouldn't necessarily be informed of that. But
gotcha.
I do know there are tribes litigating that issue and winning that issue, and some have lost that issue, and so obviously it's going to depend on case by case.
It's kind of a legal thing that's always floating around in the background of our legal coverage on our channel, is that the Arkansas riverbed, and that the tribe owns it, but there are businesses that have been going and, like, for instance, taking the gravel out of the riverbed and stuff for years.
Interesting.
Yeah, it's been a long going thing. So
something for the nation to think about. Yeah,
it is. If Chief's office or anybody is watching this, might look and check that out as far as the reservation and tribal sovereign claims on the riverbed. And I know it had to have come up at some point because we worked with the city of Tulsa on the dam project and other stuff, but the question was just basically, do you know of any lawsuits? And we don't yet. So
I don't right now. No.
Okay, let's see. There's a question popped up. The requirements for tribal consultations are routinely neglected with federal programs across the spectrum from education to infrastructure. What can be done to improve compliance? Is there anything that the tribe can do to try to get the federal government to do what they're supposed to do with all of their various programs that they're supposed to be doing?
Creek Nation has been trying so hard, and I will say it is disappointing because we did send a letter to Secretary Holland, and I think, and this is probably true for a lot of folks, I think there was a thought of, we have a Native secretary, Native burials, protection of Native sacred sites is going to be a priority, and we haven't gotten in the engagement, consultation, or response that I think we thought would come with having a Native secretary.
Yeah.
That said, we continue to engage on this. We continue to send communications to them. Of course, we're suing them. So hopefully, if that turns out in our favor, then they could be required to comply with federal law and sort of, forced by judicial order to engage in consultation with us. And that's something, of course, that's a remedy that we're asking for in this lawsuit. I think, I know tribal citizens have various points of engagement with people in different federal agencies, and you never know what could happen if you're talking to someone at BIA in the regional office, that serves Oklahoma, and you mention, hey, it's just so disappointing to see BIA stand by and do nothing while federal law is being violated and NAGPRA's being violated, and when is BIA going to do something about the desecration of hickory ground? It doesn't hurt for everyone within these agencies to hear these messages, because all it takes is one passionate person who's a federal agent, a federal service, someone who's working for a federal agency to try to do the right thing. Right?
Yeah, and also along with your point is that there's nothing that any federal agency person that's not doing what they ought to do, there's nothing that they would want more than for it to get swept under the rug and nobody to talk about it. Then they can sit in their office all day and not do nothing. So
exactly.
We're almost at the 30-minute mark here. I did want to thank you for coming on tonight, because I know you've got things you've got to do, but also I wanted to ask you what's the future look like here? Do we have a court date? Do we know any of the hard dates or times or anything?
We don't. There is a little bit of a pause because it takes 30 days for the mandate to issue from a circuit court opinion, And what that means is it just sort of gives everyone a chance, like, they could ask for a rehearing on bonk. So they could ask the entire 11th Circuit to hear this. I feel like I would be surprised if they do that, because it's a unanimous decision authored by the chief judge of the court. So I don't think, but you never know. Anyway, so we're not necessarily back in the district court just yet. But my guess is the district court might have some sort of scheduling conference in the next couple months to kind of get us back on track. And of course, we'll be inquiring about that as we want to move forward as expeditiously as possible. But yeah, so we have a little bit of a pause while we wait to kind of let the dust settle from the decision.
Okay. And there's a question that's popped up here, and I'm just gonna try to answer it myself, because it's about whether Native parents should sue for violations of JOM, etc. Ms. Nagle can't give specific legal advice to people for their problem. I mean, let me try to. If you're a Native citizen and you're seeing violations of federal programs like JOM or something like that, is it going to be beneficial for you as an individual to file a lawsuit, or is this something that tribal governments have to do?
Well, it really depends on the exact situation. And I'm sorry, she pulled the charger out of the laptop, so I'm just trying to preserve the laptop charging. Those kinds of things, I would check in with the Attorney General's office and let them know what's happening. You never know; it might be something that the tribe would have the right to sue about. It might not be, and it might be that you as the individual parent would have to sue. But certainly I would inform the AG's office of whatever violation is taking place, and seek out the advice of the AG's office on what to do.
Okay, sounds good. Well, we are at 26 minutes, so it's looking like it's about time to wrap. Is there anything about this decision that we haven't talked about that you think is important to mention?
I just think it's amazing to see a federal court really understand the significance of hickory ground. I've litigated a lot of these cases in federal courts, and oftentimes Native burials are not taken seriously by federal courts. And this court really took the time to explain that hickory ground is sacred. It is uniquely significant to Muscogee Creek Nation, and specifically Nico Thompson and the members of Ojibova. And I just think it's really remarkable to see that. I think probably has a lot to do with the hundreds of tribal citizens and tribal leaders who went to Atlanta, and Muskogee media, thank you so much for covering it, and thank you to everyone who came out, because I think that we had a powerful presence there, and I think that presence was felt in the courtroom, and I think it made a difference.
Awesome. All right. Well, thank you so much for joining us again. And I don't see any more questions. And we are going to keep you guys updated. I did want to let you guys know that we have a live wire on Thursday the 17th at 6 p.m. on the upcoming performance of Shell Shakers. So if you guys are interested in that, I know we've been covering the development of that for a long time, so you guys can tune in and ask whatever questions you got. Ms. Nagle, thank you again for joining us, and thank you to you guys watching for joining us, and we'll see you again. Mado Hadum Chihichat Lees.
Thank you so much, Mado.